Good morning. Today, tip number 12, we will discuss general exceptions. The general exception sections from 76 to 106 IPC now being incorporated, same, with little bit variation under BNS Bharat Nyaya Samhita. There are 7 categories of these sections. Number 1, mistake of fact. Number 2, judicial. Number 3, accident. Then absence of criminal intention, act done by consent, trifling act, private defense. To make you understand, I would like to say, so far a mistake of fact is concerned, if a superior officer commands a police subordinate or army subordinate to fire at mob, and if he fire, it is that he is doing it by mistake of fact. Then Tolson case. Tolson case was that wherein a wife married believing that her husband died. Therefore, bigamy conviction against her was set aside in Tolson case. Ignorance of fact. Then the most important thing is in R versus Pins, person was prosecuted for abducting a girl below age of 16 years, and he was believed she was above 18 years. The accused held to be guilty in R Pins case because the certain things he cannot plead innocence of the fact. Judicial Act, a simple understanding that if a person who hangs as per Judicial Act should not be hanged because he should be exempted. That is general exemption. Then accident. For understanding the accident, a simple accident was when a man was working with hatchet, the head of the hatchet flies and hit a man, and he has no intention to commit that act. Therefore, he is being allowed to go free. So far accident are concerned, it is particularly 304A cases. Reason to believe, bona fide belief, reasonable understanding. Everything should be there to plead accident instead of negligent act. There is slight difference between rash and negligent act or accidental act. To prevent some accident, he cannot avoid it. Another thing which he has now charged, which is he can plead accident. Then absence of criminal intention has got several heads. Number 1, to avoid harm to other person, something happens accidentally. Then act of child. Child is below 7 years, below 12 years, and below 18 years, and below 18 to 21 years were categorized in the Indian Penal Code. Thereafter, you see under Juvenile Justice Act, some other cases of Supreme Court incorporate to ascertain the mentality of the accused, child accused. A lunatic, Magnaton rules are there, lucid interval is there. The act of that person who claims lunacy must prove that at the time of committing the crime, whether he was sane or insane has to be understood. Intoxicated person. Voluntary intoxication, involuntary intoxication plays a vital role to claim this defense. Bona fide act for another's benefit. Then communication made in good faith. Act done compulsion or threat. That means by force. Somebody causes a person to commit murder or rob or rape So he can plead that it was not his intention, it is under threat of his life. To act then to avoid other harm, all these things are there. That you have to go through it. Then question arises, act of consent. So here is also most important thing is consent and submissions are both are different. Consent and submissions are both different. All consent involves submission, but not all submissions is with consent. So that is most important. A mere submission by a person who does not the nature of act is not a consent. That is a voluntary non-fit injuria. All these things are there. Then slight harm. That means maxim de minimis non curat lex. De minimis non curat lex. The Indian Penal Code simply says no ordinary man would complain such a trivial injury or act. That is called right of private defense. Right of property, right of our persons or our family members you can do, but you should not exceed the private defense. There should be certain restriction. But that what they say in Ajmat Khan versus state, AR 1952 SC 165 says, man cannot be expected to calculate what will be the minimum at the time of using his defense. Yes. Then you see, when there is necessity, a person entering your house, and you can very well avoid him entering the premises, but that's not when he leaving and ran away. You cannot chase him and do it. This is called exceeding right of private defense, which plays a pivotal role while bringing the offence of 302 to 304 part 1 and other things are there. Best wishes.